Hi everyone. We are delighted to meet you again for this new webinar dedicated today exclusively to GDPR. Please note that you have the possibility to ask your questions during this intervention via the dedicated tab. Otherwise, please note that you have the possibility to ask your questions at the end of this webinar. So this webinar has been prepared for you by Ipside Avocat, the department of Ipside led by Gwendal Barbeau, partner and attorney at law at the Paris Bar. Just a quick presentation of our department. Ipside Avocat has developed expertise in all areas of IP, in patent, trademark, design and model, copyright, both in litigation to ensure the defense of your rights and in consulting. The department has also developed an important contractual activity, and we draft all types of contracts related to IP as well as commercial contracts. And we also have a team dedicated to the protection of personal data. And let me introduce myself. I am Audrey Pichot, member of Ipside Avocat, lawyer at the Paris Bar, and I am delighted to present you today this webinar dedicated to GDPR. So this webinar is the opportunity for you to review the CNIL's annual activity report or the CNIL for 2019, the CNIL, which is the French Data Protection Authority. First of all, we note an increase in complaints compared to 2018 of 27%, as you will see in your screen. These complaints were mainly aimed at denouncing excessive surveillance of employees in the workplace, and in particular through the use of video surveillance, excessive data collection, the non-respect of the rights of individuals, the lack of data security, and the reception of commercial prospecting without prior consent. This report has also been the opportunity for the CNIL to recall the fine it had imposed in 2019 against Google and its privacy policy, which is a huge fine of 50 million euros because of serious violation of GDPR, and notably because the information provided to the user was not always clear and easily accessible. So the results of this report are the opportunity to show you that the CNIL has finished with the tolerance period it applied after the entry into force of the GDPR. Now the CNIL has a real control activity, and it is now time for companies to start the compliance process if they have not already done so. So what is the program we offer you today? In the first part of this webinar, we will talk about the first steps to start your GDPR compliance. We will then, in the second part, discuss the new rules of the CNIL regarding cookies banners. And finally, we will conclude with an update on authorized practices for the collection of health data, which is a current topic in this period of pandemic. So first part, compliance with the GDPR. What are your first steps? Where do we start? Before taking any steps, we advise you to appoint a DPO. Why? Because this is the person who will lead the compliance process, who will oversee your compliance within your company, and who will be responsible for information, advice, and internal control. So DPO is a key player, and this is a person who will help you to start your compliance with GDPR inside your company, to centralize all information to start your compliance. So step one, we recommend you to map your treatments so that you can record of processing activities, so you can keep a record of processing activities. We recommend you to audit contracts concluded with service providers, and finally, we recommend you to make your website GDPR compliant. So step one, the GDPR has removed the requirement for prior declaration to the CNIL, and now the company is required to document its compliance. So the essential step before any compliance process is to identify the personal data processing you are implementing. To do this, we must ask ourselves simple questions. Who, to identify who is collecting and processing personal data and who are the data subjects. What, to identify which category of personal data are collected and processed. If you are collecting sensitive data. Why, to identify the purpose of each process. How, to identify the origin of the data collection. Until when, to identify data retention storage. And where, to know where the data is hosted and if you are transferring data outside the EU. And after you, once you have asked all these questions, you are able to establish the processing carried out within your company. After this first step, you are able to fill in all this information in a treatment register. The treatment register is necessarily written. It can be either paper or digital. And the content of this register is laid down in Article 30 of the GDPR. So you have to mention inside your record name and contact details of the controller, its representative, and name of the DPO. You have to mention also the purpose of each treatment, a description of each categories of data subjects and categories of personal data, recipient category, and data transfer. It is also a good thing to write data retention storage and a quick description of technical and organizational measures to ensure the security of personal data. So let's move on to step 3, the audit of the contracts concluded with your service providers. GDPR, this applies to your service providers. This step applies to your service providers who process personal data on your behalf, such as IT service providers, marketing or communication agencies, or accounting services. And since they collect and process data on your behalf, these service providers have the status of processor. And because they are processor, they have obligations to respect, like obligation of transparency and traceability, obligation to guarantee the security of the data processed on your behalf, and obligation to provide assistance, warning, and advice on the processing operations you wish to carry out. So GDPR requires the presence of mandatory information inside the contract concluded with processors. So you will then have to revise your contracts if your contracts do not contain personal data clause. So now let's move on with the final step we recommend you. Make your website GDPR compliant. As your website collects personal data, you must insert mandatory mentions relating to the processing that is done on this data. So you must be as transparent as possible about the data you collect and process. The obligation to provide information is a key principle of the GDPR, and you must deliver it in a clear and accessible way. To do that, we recommend you firstly to write a legal notice, which aims to clearly inform users about your company's identity. Secondly, we recommend you strongly to write a privacy policy, which will include all information relating to the collection and processing of data on your website. And finally, we recommend you to write cookie policies, which aims to communicate in full transparency on the identity and characteristics of cookies you may use on your website. And we also recommend you to write a cookie banner, which must appear as soon as the people connect to your website. But we will come back together in the second part of this webinar on how you have to write your cookie banner, because you probably know that the CNIL has changed the rules concerning cookie banners. So what is your checklist? First, mapping treatments. Keep a treatment register, audit contracts with processor, and make your website GDPR compliant. So we will now move on to the second part of this webinar on the new CNIL regulation on cookies. So as you probably know, the CNIL has published its guidelines concerning cookies in July 2019, followed by a draft recommendation that is not yet final. But we will take stock of what is no longer accepted and what needs to be set up to be in compliance. So you have probably installed this type of banner on your website that says, by continuing your navigation, you accept the use of cookies to provide you with a better user experience. So you have to know that this type of banner is no longer valid. Why? Because GDPR has strengthened the consent requirements for individuals. What are the GDPR consent requirements? Consent must be freely given, specific, informed, and unambiguous. Unambiguous, which means that consent must be expressed by a clear positive act. So scrolling is not consenting. So how to rewrite your cookie banner? So you have to provide a certain amount of prior information inside your cookie banner. Why? Because as we said, consent must be informed, which means you have to deliver information prior the user is able to give its consent. So inside your cookie banner, you have to provide the following information concerning the identity of the data controller, the purpose of cookies, if the cookies are functional, or marketing, or are used for audience measurements. So you have to tell that information. And also you have to inform about the fact that people can always withdraw their consent. And this information must be easily accessible before the person is given the opportunity to express a choice. You have to offer the possibility to express consent for each separate purpose, which means for each type of cookies. And you can also the possibility to offer the option to accept globally cookies, globally all cookies, but then you have to know that you have to offer the possibility also to refuse all cookies. And keep in mind that the slider for accept globally cookies cannot be further promoted. Now we will move on about the subject of cookie walls. What are cookie walls? This is a practice of blocking access to the website to the person who does not consent to the deposit of cookies. You don't accept cookies, you can't access the website. This is what are cookie walls. And about that subject, the CNIL considered in its guidelines that the practice of cookies walls was contrary to GDPR, since it did not allow internet users to consent freely. And after the publication of that recommendation, various professional, it's not recommendation, sorry, it's guidelines. After the publication of these guidelines, various professional associations have brought legal action to overturn the CNIL guidelines on that point. And a decision was recently rendered by the Conseil d'État this month. And the Conseil d'État ruled that the CNIL could not prohibit the use of cookie walls because it is not expressly mentioned in GDPR. So the CNIL does not have the power to prohibit something, and more particularly, ban of cookie walls, because it's not expressed into GDPR. So can Can we use cookie walls? Apparently we can, but to be sure, let's wait until the CNIL revises these rules. And she promised she will do so. It will do so. Why, according to us, it is important for you to revise your cookie banner today. Because cookie compliance is announced as one of the control priorities for the CNIL, which is the French Data Protection Authority. Control missions will be carried out 6 months after the final publication of the CNIL recommendation, which is scheduled for September 2020. So control should start in March 2021. So we recommend you strongly to review your cookie banner to be GDPR compliant. So we now move on to the last part of this webinar dedicated exclusively to health data collection. In this time of pandemic, companies are asking themselves what measures they need to implement to ensure a safe return to business. And as health data have the status of sensitive data, they have a specific regime. So we will see together what you have the right to do and not to do. First, what does GDPR say about health data? It starts by giving a definition of health data, which are personal data relating to the physical or mental health of natural person, including the provision of health data care services, which reveal information about the state of health of data person, of health of the person. So the principle laid down in the GDPR is that the collection of health data is forbidden. And it also provides for exceptions. Processing is permitted if it is necessary to safeguard the vital interests of individuals, and processing health data is also permitted if it is necessary on public health grounds. So clearly, what are the good practices? So you can't implement systematic and generalized data collection. You have to limit to the strict minimum the collects of health data, which is a key principle. So what is prohibited by the CNIL? The CNIL prohibits the following practices. First, the constitution of a file containing temperature data of employees. The CNIL also prohibits the installation of automatic temperature capture tools, and it is also forbidden to organize screening campaigns. Only competent health data can organize such campaigns. And what is allowed? Temperature measurement without the results being saved. If you simply check the temperature with a thermometer at the entrance to a site to your company without keeping any record of these results, then this practice is not covered by data protection regulations, so you are allowed to do this. The implementation of an internal process for voluntary employee reporting to alert the company that an employee has been contaminated so that the company can alert the colleagues he came in contact with. And you have also, this is allowed, this is a requirement, you have to inform employees of cases of infection inside the company. And keep in mind that in any case, whatever solution your company implements, you must first and foremost ensure complete transparency with respect to the people concerned. So you have to inform people. For instance, by placing information notice at the entrance to the company, or for instance, through notice at the bottom of the data collection forms. So at the conclusion, we give you the checklist, the following checklist. So you have to start the compliance process. Start the GDPR compliance process inside your company since CNIL has shown its control activities for 2019. We recommend you to review your cookie banners to apply new rules defined by the CNIL. And we recommend you to protect health of your employees by complying with health data collection rules. So if you have any question, please feel free to ask.